Well, Chala, why don't you go ahead?
All right.
We have on, and I'm Cheryl Coleman, your host and realtor, and Paula Hazard,
Hey everyone, I'm Paula Hazard. I'm your investment person.
my co-host, and Adam from my team is on, and Stacy from my team is on. We just went to a really great meeting at the senior center. There was about 100 people there.
Wow.
We were there this afternoon, and that
What kind of meeting?
It's a networking meeting of people that work with seniors, and they used to meet every month before COVID, so they haven't met in 2 years. But there is everything from Medicare to Memorial to you name it. I mean, if you needed anything, there's at least 3 of everything there. And so it is a really good meeting. And so they meet every other month.
So do you get a booth?
No, it's an actual networking meeting.
Oh.
So we all have lunch and
Oh, nice.
And somebody sponsors the lunch, but it was purely networking. No speakers or anything, just we got up, and I mean, when you have 100 people and each get a minute to say who they are, that's your meeting, you know. Yeah. So I was surprised how big it is. And boy, I keep forgetting how nice that senior center is. That is one nice senior center. But Paula, why don't you introduce Chala? She used to be in my networking group. I haven't seen her in ages, but we are going to get together.
So I am happy to introduce Cagla Basar, that we met quite a few years ago. She's an attorney right here in Huntington Beach, which is very convenient for everybody. And she's going to talk about estate planning and trust today. So welcome, Chala.
Hi, everybody. Thank you, Cheryl and Paula, for having me, for asking me to present. So I have a little PowerPoint too, so I can share my screen. So you're not, oh, I can't share my screen. It's okay.
No, I will allow you to share your screen.
So while you do that, basically my focus is estate planning, trust administrations, and probates. Today, I think, Paula, you had told me to focus a little bit more on the estate tax part of it also. So what I'll probably do is I'll kind of just start with just basics of estate planning, just living trusts, powers of attorneys. I don't know how many of you already have an estate plan. I know Sandy, so, yes. But I think Sandy, even you'll get a lot of information out of this, I think. Yes. And so some of the information you guys might already know, like the basics of living trusts and what a probate is. Cheryl, you probably already know what a probate is.
In the probate court, but I must say it's my favorite because that's where the judge tells you that you deserve your commission.
I love probates. I love the structure of probates, and you know, there's a process to it, and there's a lot of paperwork, and it takes a long time, unfortunately, in California, and it's expensive for people. But for an attorney, it's, you know, why we go to law school. So let me see if I can, okay, now I can share my screen.
There's 2 things that you're going to need to do as host. You might, while you're speaking, you might get a little ding, and you'll look at the top of the screen, and that's someone trying to get into the meeting. Just hit admit.
Okay. Sounds good.
And then when you're done, go back and make me the host. So.
All right, sounds good. Okay.
They have updates now where we can have 2 hosts, so I'll have to start doing that, but I never know.
Yeah, I thought you could, but I'm not.
Yeah, I have to do it in the beginning, so we're.
Okay.
You're good.
All right. Okay, so I'll first start with the goals of estate planning. A lot of the times people think that, you know, having an estate plan or having a trust is for people who have lots of money, which of course is a misnomer. It's for everybody. Everybody over the age of 18 would need some sort of estate planning, whether it's a living trust or a simple will, powers of attorneys. So I'll quickly talk about those documents too. But basically the goals of estate planning is to plan for incapacity, to do some tax planning if needed, which I'll talk about estate taxes and when they would apply. It allows you to do retirement planning, meaning how to make sure that your assets will grow and last, and how you can pay for long-term care, you can do that through the right type of a trust. So if you ever needed Medi-Cal benefits, for instance, there are certain trusts that you can set up that can help you qualify for Medi-Cal benefits. Medi-Cal, which other states call Medicaid, not to be confused with Medicare, is a great government program that pays for nursing home benefits. In California, we call it Medi-Cal, other states call it Medicaid. We operate on a totally different types of rules than other states, and we have a little bit more friendlier rules. So it's a whole other presentation in and of itself, and the rules are going to change on that. So maybe one day we'll talk about that. But going back to estate planning, of course, other goals of estate planning is protecting adult kids. That could be kids that have maybe creditor issues, divorce issues, drug addiction issues maybe, or they have special needs. They might have a disability. So you never want to leave someone with a disability money outright, because now you're gonna, if they're on government benefits, you're gonna hurt that government benefit, or they might not be responsible. So you might not want to give them a lump sum money. Or if you have minor kids, so if you have beneficiaries that are under the age of 18, you're not going to be able to leave them money outright. So you have to do some proper planning for that. Handing down legacy to children and grandkids. So if you own a family-owned business, you're going to want to make sure that your business can transfer to your loved ones, estate tax-free, probate-free. So with proper planning, you can transfer your assets to your loved ones smoothly. And of course, estate planning saves you money in the long term, which I'll talk about how you can do that. So not just for the wealthy, for sure. So when you have a proper estate plan, and of course, I don't know how many of you have an estate plan, hopefully many of you, it gives you control, right? It gives you control over who's going to make decisions on your behalf if you were to become incapacitated or if you passed away. So when you have a trust in place or a power of attorney in place, you're the one that has picked the person who's going to step into your shoes and take care of your healthcare decisions, your financial decisions for you. Another big benefit of estate planning is it avoids family disputes. So even in families, in my experience, even in families where kids get along, everything is great, when a death happens or when a family member gets sick, disputes happen, siblings start to fight because it's a stressful time for everybody. So you want to have your plan in place and you want it to be clear and concise so that if something happens and your family members look at your trust, it's clear what your wishes are. So all your family members have to do is honor those wishes and follow your instructions. Okay. So what happens if you don't have an estate plan? So basically, if you have, let's say, bank accounts that you have joint owners on. So if you're married and you have accounts with your spouse, if one of you passes away, those accounts will just go to the remaining owner on it. Or if you have your kids on your account, it would just go to your children. Or if you have retirement accounts, life insurance policies, basically any accounts where you've designated beneficiaries on, it would just go to those beneficiaries if you passed away. Any other asset that you have would go through probate. So what is probate? It's a court process that happens when someone passes away. So as an example, let's say someone dies and they own a piece of real estate and they have a couple of bank accounts in their name. What would happen is all those accounts would be frozen. All the assets would have to go through the court process before it can pass to whoever the heirs are. In California law, and every state determines who your heirs are. So if you don't have a will, if you don't have, anything in place, California law would control who your assets are going to go to. This court process, I should have updated this. After the pandemic, this process is way more than 8 months. It used to be just 8 months to a year, which is still long in my opinion, but now it's at least a year to about 2 years. Everything is just very backed up. So just to get a court hearing, it takes about a month and a half, depending on the type of hearing. And for everything to be concluded, most of my probates are now taking at least 2 years. even the simplest one where no one's contesting, it's just one child is inheriting everything. Orange County is the worst. LA, if you can believe it, is a little bit better. And it's an expensive process. So as an example, I put a little example here. So let's say we have just one home in the estate and the fair market value of that home is $800,000. Just the attorney fees and executor fees would be $19,000 each. The court fees will be several $1,000s. So it's quite an expensive process, and that's based on the fair market value. So if you have a mortgage on the property, they don't count that against it. It's all based on the fair market value. So our goal is generally to avoid this process for the clients, of course. So, and it's a public process, meaning if anybody can go to the court and access all of the information related to your case. So they can see what's in your estate, who the heirs are, all the petitions that have been filed. So unlike a living trust, which never gets filed anywhere, the probate process, unfortunately, is public. The one advantage is it is court supervised. So some people like that. Some people like that there's a judge that's kind of overseeing everything, because when you have a living trust, there is no judge. So you have your trustee that manages everything. I'll talk a little bit about trust soon, but the probate process is court supervised. What happens is generally a family member would petition the court to get this process started, and then the court would appoint an executor, whoever, whoever's the petitioner, and that executor's job is to collect all the assets, pay your debts, file your tax returns. If there's an estate tax due, they'll have to file an estate tax return, which I'll talk about. And then their ultimate job is to distribute your assets to your heirs, whoever California says your assets go to. By the way, if there's any questions, you can always stop me. So I don't want to keep talking and bore everybody.
I have a question. So how far behind is Orange County Probate Court running right now? I know like last year when I had one, it was like 9 to 18 months, they said. So.
Yeah, that's a good average. So by law, they have to give us a hearing. When we start the petition, they have to give us our first hearing has to be within 30 days, but they're not even really following that rule anymore. I just recently submitted a petition. I think our hearing date was 2 months out. I mean, technically I can say, no, you have to abide by the rule and give me a sooner hearing date, but they're just very slow. So right now, the initial petition has to be within 30 days, but any subsequent petitions that we file, they're usually 3-4 months out at least. I've even gotten a hearing date to next year. So it's pretty far behind, yeah, unfortunately. Okay, but that doesn't mean, of course, the house can't be sold. So if there's a house in the estate, once the executor is appointed, the house can be sold. I think we have someone that just came in. Okay, here we go. The house can be sold. It just can't, the probate, basically the case can't close and the heirs just can't receive their distributions until the whole process is over. So that could be about 2 years, yeah. And I think Natalie just entered.
Okay.
All right. Okay, so before I touch on trusts, I just want to quickly touch on powers of attorneys and advanced healthcare directives. So a financial power of attorney is basically a document that anybody over the age of 18 should have. It's a document that allows you to give someone else the authority to act on your behalf for any financial decision. So that would be things like filing your tax returns, signing contracts, buying assets. So you definitely want to name someone that you trust. You can name more than one person, of course, and you always want to name backups. So if you name one person, you always want to put alternates. The goal of the power of attorney is that in the event you're incapacitated, that person can step in and pay your bills and take care of everything for you. If you have no power of attorney, what would happen if you became incapacitated is the family member, a family member would have to petition the court and get what's called a conservatorship. Conservatorships are also court supervised processes. And in this situation where what happens is the family member is telling the court that you're incapacitated, you're unable to manage your money. This is also a public process. So these I don't like. I always feel so bad for the usually it's an elderly person with dementia, you know, because what happens is the court will send out an investigator to talk to the person and they'll make a determination. Sometimes even if we think that person is incapacitated, the court will think, no, they can manage their own decisions, so they'll decline. So it's not easy to get for sure, but ideally we never want to have to be in that situation. So check to make sure you have a financial power of attorney. And it's always a good idea to update this document, because if too many years go by, if let's say 10 years go by and you haven't updated this, it's likely that the banks will not accept it. I've seen situations where the banks will reject a valid power of attorney because they'll say it's too old. So make sure you periodically check to make sure it's recent. The other document is the Advanced Healthcare Directive. So what this document does is, if in the event you're in the hospital and you're unable to talk to the doctor yourself, you get to name someone who's going to make medical decisions for you. And then in this document, you would also put your medical wishes. So things like artificial life support, organ donation, whether you want to be buried or cremated, whatever is personal to you, you can put that information in that directive. Another healthcare document is the HIPAA waiver. So these two documents go hand in hand. HIPAA is a medical privacy rule that says that all of our medical information is considered private. So without our permission, our doctors are not supposed to talk to anyone, not even to our spouses, believe it or not, with a few exceptions. So what you want to do is you want to make sure you have a HIPAA waiver that lists all the people that you want to authorize the doctors and nurses to speak with. So your spouses, your kids, neighbors, whoever you want to put on there, so that they can obtain your medical records. That's a very important document too. I've seen that come handy, especially when someone dies and let's say there's going to be a malpractice suit. You know, the family members can obtain all the medical records and you know, find out what's been done, and so it's very, very important to have. Okay. If you have an estate plan that was set up before 2005, you want to double check to make sure you have the HIPAA, because HIPAA passed in 2005, so you might not have it. Okay. So living trust, what is a living trust? So it's basically a document very similar to a will. But what happens with a trust is we have three parties. We have the trustor, that's you, that's the person that created the trust. We have the trustee, who's in charge of the assets in the trust. So that would also be you while you're healthy and able. And then we have the beneficiary. So that would also be you, most likely, but it would also be people that you want to leave your assets to upon your passing. I used to work for a law firm where the attorney I worked for would always refer to living trusts as a bucket. You know, you think of it as a bucket where you put your assets into the bucket. It's very important to put your assets into the bucket, because anything that you leave out of the bucket is going to be subject to probate. So for those of you who have a living trust, this is actually a good review. Hopefully one thing you'll take out of this presentation will be that you'll double check to make sure your bank accounts, your checking, savings accounts are all in your trust. The one thing that wouldn't go into your trust is your retirement accounts. So if you have 401ks and IRAs, you want to double check to make sure you have beneficiaries listed on them. But everything else you can put into your trust. Even life insurance policies, you can name the trust as the beneficiary on that. I generally don't recommend naming your living trust as the beneficiary of your retirement accounts, just because those type of accounts are treated differently for tax purposes. They're subject to income taxes. So it's a good idea to just put whoever you want to leave those accounts to as the beneficiary. Okay. Hopefully, if there's any questions, feel free to stop me. All right. So what the living trust will do is, of course, it avoids probate. That's the main. A lot of my clients come to me because they want to avoid probate. When you have a living trust set up and all your assets are in your trust, upon your passing, there would be no need to go to court. So everything could go to your loved ones completely, way faster and without the expense of going through the court system. Of course, your trustee's job is to make sure to transfer your assets to whoever your trust beneficiaries are. So that way your wishes would get honored. I'm going to talk about tax planning strategies in a little bit, because one of the also biggest advantages of a living trust is it allows you to plan for estate taxes if you have a taxable estate. You can also do some disability planning. So if you have a family member, a beneficiary who's special needs, if they have a disability, you can set up a special needs trust for them within your living trust instead of leaving money outright to them. So that's a great feature of it. Of course, like I said earlier, it is private. The trust never gets filed anywhere. That's a common question I get. People will say, well, where do we record this? We don't record the trust anywhere. You can always update your living trust, which makes it very flexible. In fact, you should update your trust periodically, especially if there's a big change in your life. You know, if you get married, if you get divorced, if there's a new family member, law changes that happen, which have been happening pretty frequently lately. So you always want to, review the trust to see if there's been a change that impacts you. When we set up a living trust, we always set up a will also. Another common question I get, do I need a will if I have a trust? The answer is yes, because it's very common that people will forget to put something into their trust. Generally, that's a checking account. I don't know why. Maybe people think, oh, I don't keep that much money in there, so I don't need to put it into my trust. It's true that it won't get tied up in court because you'll have a will that says, I give everything to my trust. That account that you might forget outside of your trust, it won't get tied up in court. It'll just pass to your trust if something happens to you. So it's not really the end of the world. But you always want to make sure you want to put the big assets into your trust. So by big assets, I mean anything that's worth more than $166,000. So it's quite a lot. You have a ways to go. So if you have a couple $1,000s in a checking account that's just sitting in your name, that's fine. It's not going to get tied up in court. How often should I update my trust? Now, these are some of the common questions I get. I generally recommend 3 to 5 years. So if it's been more than that, then you should have a trust review.
Can you go back to the bank accounts? Did you say that 166,000 is the limit? Anything over that would?
Yeah, anything over that. So let's say you have a trust and then there's an account that's worth $200,000 and the person dies. What will happen is that $200,000 will be subject to the court because it's worth more than $166,000. So the will not cover it. Yeah. So
what if you have someone on the account with you?
Then it's fine. It'll just go to that person. So
Okay.
yeah, if you have a co-owner on it, that's good. Or if you have beneficiaries listed on that account, it'll just go to those beneficiaries. Yes.
Okay.
With husband and wife, I see a lot of husband and wives, they'll own real estate as joint tenants or community property with right of survivorship. If one of them dies, it'll just go to the other one. But of course, the problem comes when the second spouse dies, right? So it's not a good strategy. You still want to set up a trust to make sure, what if you both die at the same time? Because most spouses travel together. Okay. Do I need to update my trust if I purchase a new asset? Not necessarily. My recommendation is, if let's say you sold your house and you bought a new house, you just want to make sure you buy it in the name of your trust. You might not necessarily need to make any changes to your trust because the trust name doesn't change. Of course, you can do a trust review. You can contact your attorney to see if you need to do anything else. But when you buy a new asset, you just want to make sure it's in your trust. You're buying it in the name of your trust, and that's all you need to do generally. Okay, So we talked about this, but how do you put assets into your trust? It depends. So if you own real estate, you would need to do a title change. A lot of the times your attorney will handle that. I know I do for my clients. So when I generally set up a trust for my clients, I will ask them how many pieces of real estate they own in California and in other states. You can put your out-of-state assets into your California trust, and I will prepare the deeds for them, and we send it to the recorder's office. When you buy a new piece of real estate, make sure you tell your realtor that you have a trust. In terms of your bank accounts, you would just do that at the bank. You would go to your bank and let them know you have a trust, and they'll probably ask you for what's called a certification of trust. Most attorneys, we do provide a certification of trust when we set up a trust for our clients. So you can always, again, ask your attorney for that. Worst comes to worst, you can provide a copy of your trust to your bank. And most of the time, they just need the signature page and the first page of the trust. Same with your investment.
I do find about 50% of the time the even though the property's in the trust, it wasn't recorded properly, which is another reason to have a good attorney like Chala that's going to do that for you. And in September, we're actually going to find out whose properties are really in the trust. So we're going to have the Vice President of Orange first title here and let everybody find out if they're, how their property is recorded. You'd be really surprised.
Yes, very.
Sometimes the county just screws up, but
100%. I've seen the county lose deeds. I've seen the county, mess up, especially now with the pandemic. I'm seeing more and more mistakes. One thing I also see is when people refinance their house, the lender takes the property out of the trust and they forget to put it back in. You wouldn't believe how many clients come in saying, oh yeah, my house is in the trust. And then I'll always do a title search because, I'm just like that. I always like to check, and we'll find out, oh no, you refinanced and they never put it back in. So one way to check is you can always take a look at your property tax statement, and it should say TR next to your name. So if it does,
asked what in the chat, you'll see what happens. So if the property is not recorded properly in the trust, what happens? So we get it fixed, but it does cause.
So
problems.
what happens? So depends. So if the person who created the trust, if you're still alive, of course, we can correct that. That's an easy solution. We would prepare the deed, immediately send it to the recorder's office. If there was a mistake in the deed, a correction deed could be done to correct the mistake. What happens if the person has died, right? I see that also a lot. So if the person has died, we would probably have to go through the court system. And we wouldn't have to go through a full probate, which is great. There are California rules that allow us to avoid the probate process. What we usually do is we petition the court and explain to the court what's gone wrong. So if it was, let's say, the lender's fault, we usually explain, because of negligence, it was just left out of the trust, but the intent of the person was to put it into their trust. Orange County almost always approves those petitions. I've never had one that got denied. Because the courts don't want more probates, right? They want to avoid probate, so they generally approve it. So hopefully the mistake will be realized before the person dies. So always check your property tax statement, especially if you refinance your property. Okay. Tax law changes. So now let's talk about estate taxes. So the good news is there's no estate taxes in California, right? Great. But there is a federal estate tax, and the federal estate tax exemption this year is 12 million, just a little bit over 12 million. It's been going up because it's adjusted for inflation every year. Now, what that means is anybody that passes away and their estate is worth more than that exemption amount, it will be subject to a 40% tax. So there are ways you can, of course, defer estate taxes or completely eliminate estate taxes. It doesn't really impact a whole lot of people just because the amount is so high. That amount is set to expire in 2026. It'll go back down to 5 million, which it'll get adjusted for inflation that year also. And so it'll probably be around 6 million. So it still probably won't impact a whole lot of people, but being in Orange County, it probably will impact a lot of Orange County folks. So I'll talk about some strategies that folks can utilize to reduce estate taxes or completely eliminate estate taxes. It just requires
That's per person, right? That's per person.
That's
so
right,
A couple
per
would be
person.
12.
As a couple, you have 24 million, so you can double it. So I'll talk about that too. Yes. Before I get to the next slide, just really quick on gift taxes. The federal annual gift tax exclusion is 16,000 per donee this year. It was 15,000 last year. What that means is you can gift up to 16,000 to each person. So if you have, let's say, 3 kids, you want to give them each $16,000, you can do that. And you don't have to file a gift tax return. You don't have to do anything. And there's no taxes to be paid, which is great. You can give them more than $16,000. There's not going to be any taxes due. You just have to file a gift tax return. A lot of people think that this is a very common misunderstanding that people will have is, oh, if I give more than 16,000, I'm going to owe money. That's not true. We all have a lifetime gift tax exclusion equal to the estate tax exemption. So that means we can all, during our lifetime, we can each give away 12 million and we wouldn't owe any taxes. So we have a long ways to go. And if you're married, you can combine that. So you have 32,000 that you can give away and not have to file a gift tax return, which is great. Okay. So when do you have to file an estate tax return? So when someone passes away, and if their estate is over $12 million, the executor or the trustee will have to file an estate tax return within 9 months of their passing. It has to be filed within 9 months. You can get an extension for 6 months, so you really have 15 months. There is no California taxes, so you don't have to file an estate tax return in California. You probably just have to file a final income tax return for the person that passes, but there's no estate tax return filed in California. I put a little caution here because if the decedent has assets in another state, so if let's say you have assets in New York, now I don't know New York rules, but some states have estate taxes and their exemption is like 1 million or lower. So if you have property over there, you always want to check with a tax professional or an attorney in that state, because you might have to, your trustee might have to file an estate tax return in that state. But as far as federal tax return goes, estate tax, if your estate is not 12 million, there is no need to file an estate tax return. There would be no estate taxes due, which is great. And what's included in your estate? It's everything you own, your real estate, your cash, securities, insurance, trust, business interests, everything. But that doesn't mean everything is subject to taxes, because the IRS will look at what's in your taxable estate. What that means is they'll deduct any mortgages you have, any debts you have, estate administration expenses. So if your estate is going through probate, which hopefully none of your estates will go through probate because we're having this discussion. But if there's trust administration expenses, those are all deductible. Also, any money you leave to your spouse, you can leave your spouse unlimited amounts of money. It's called the unlimited marital deduction. We can leave our spouses billions of dollars. There would never be any taxes. You can gift each other money. No taxes will be due. Same with charities. If you're making gifts to a charity, it's not subject to a tax. So giving, donations is a great way of reducing your taxable estate. And like I said earlier, the tax rate is 40%. So a lot of the times people say, oh, I don't have 12 million. But you always want to be cautious, because Congress is always talking about changing the estate tax exemption. I know there was a recent tax proposal that they were trying to lower it to 3.5, I think it was. Obviously, that's a big change. There was a time when the estate tax exemption was $600,000. That was back in the 90s. So of course, if it was that low, it would impact way more people. Certainly most people in Orange County, because just our houses would be more than that. So and anything above the exemption rate would be subject to 40% tax. So let's say you have a taxable estate. So what are some of the things that you can do to plan? So the number one thing, of course, is you can gift away your assets while you're living to reduce your taxable estate. So you can, of course, gift up to $16,000 to each of your kids, grandkids, whoever you want it, every year. And then you're reducing the size of your estate. So if you have kids or grandkids, you want to pay for their education, or you want to give them money for travel, whatever it is, you can do that. And you don't even have to file a gift tax return if it's not more than $16,000. If it's more than $16,000, of course, you're going to file a gift tax return because the IRS is going to keep track of how much money you're giving away. Another strategy is, of course, you can make charitable donations and they're never subject to taxes. So that's great. Okay, so in terms of trusts, the most common strategy for estate tax planning that I see that I do is creating AB trusts. So what that means is your trust will state that at the death of one of us, when the first spouse dies, the surviving spouse has to divide the assets into two trusts. One is called the survivor's trust, one is called the bypass trust, or the trust B, or the decedent's trust. Different attorneys call it something else. But what that means is that trust B will hold assets that belongs to the spouse that died. The benefit of splitting the assets is that when the surviving spouse dies, the IRS will not look at what's in the bypass trust when they're determining if there's going to be any taxes due for the survivor. So if, let's say, you have a $5 million estate, and let's say the exemption is $2 million, what you can do is you can put that up to $2 million into the bypass trust, and you're protecting that $2 million. And that money can grow, so it could be $3 million when you pass away, and it would never be subject to taxes. So you have that other $3 million in the survivor's trust. So when the survivor dies, the IRS will look at just the survivor trust's value. So a lot of the times when we do this division, a lot of the times we completely avoid estate taxes. The nice thing is when both spouses die, these trusts will get combined and the beneficiaries will receive the funds, but anything that's in Trust B will not be subject to taxes. So a lot of married couples who had a trust set up back in the 90s, because the estate tax exemption was so low, it was only $600,000. Most married couples had an AB trust. So if you have that, if you look at your trust, it probably has that language in there. Now, if you don't have a taxable estate, you don't need that language. So it's just unnecessary, because if there's no estate tax concerns, you don't need to do that division. So it's just unnecessary. So if you had a trust set up a long time ago, you want to look at it to see if you still need that language, or maybe your estate has grown and maybe now you do need that language, right? So that brings me to my next point, the use of disclaimer trusts. What that means is basically a disclaimer trust is the most common strategy that estate planning attorneys are utilizing right now to plan for estate taxes. What that basically means is it gives the option to the surviving spouse. When one spouse dies, the trust will say that the surviving spouse has the option to do that division, but you don't have to. So what we usually do is if one spouse dies, we look at what the laws are at that time. And if the estate tax exemption is too high and we're not really concerned about estate taxes when the survivor passes, then we don't need to exercise that. We can just keep everything in the survivor's estate. That way the survivor can do whatever they want with their money. Because when you do that division, there are some disadvantages to doing that division also. One disadvantage is from a capital gains tax perspective. So what happens when, and this is regardless of whether or not you have a trust or not, when you own an asset, let's say you bought a piece of real estate for $500,000. That's your tax basis in that property. So if you later sold it for, let's say, $600,000, there's gain on that. So it's subject to capital gains taxes. So you pay the capital gains taxes to the IRS. They want their part of that. What happens is when the owner of that property dies, the beneficiaries will get an appraisal done to find out what the fair market value of that property is, because the property will receive a new tax basis. So let's say at the time of death, now the property is worth $800,000. For the beneficiaries that inherit, that will be their tax basis. This is a huge benefit, and I hope Congress doesn't change this rule, because they were trying to get rid of the step up. Because what happens is when you receive a new tax basis, let's say the beneficiaries decided to sell the property for $800,000, they're not going to owe any capital gains taxes. If, let's say, they sold it for $850,000, then only that difference between 850 and 800 would be subject to capital gains taxes. Most of the time, especially in California, when we're talking about real estate, most of the time it's a step up, because property tends to appreciate. Sometimes it's rarely a step down. If, let's say, you have investments and let's say it's gone down at the time of the death of the person that owns those investments, it could be a step down. But I've honestly maybe come across that once. Most of the time assets appreciate. How that applies to a survivor's trust and a bypass trust is when you have the assets divided like that, when the first spouse dies, all of the assets will receive a new tax basis, which is an advantage for the surviving spouse. And then when the survivor dies and the assets are now going to the kids, only the assets in the survivor's trust will get a new tax basis. Everything that's in the bypass trust is still stuck at the first spouse's date of death value. So we don't get that second step up. And that's a disadvantage for the kids, because if they decided to sell the assets that are in the bypass trust, they're probably going to owe some capital gains taxes. So AB trusts are great when you're trying to eliminate estate taxes, but they might not be so great if you have huge gain and there's capital gains taxes. So you always want to, kind of weigh your options here. Which brings me to my next point. So, which is my favorite, actually, tax planning strategy, is portability. I think one of you just a minute ago asked, with spouses, you have 24 million. So that's called portability. So if one spouse dies and everything, let's say the deceased spouse leaves everything to the surviving spouse, the surviving spouse can file an estate tax return and elect what's called portability. Portability just means that you're letting the IRS know that your spouse passed and they left everything to you, meaning they didn't use their estate tax exemption. Because remember, we each have $12 million that we can give away. If I give my 12 million to my spouse, that means I'm not using up my 12 million, because between spouses, you can give away unlimited amounts of money. So then my spouse can file an estate tax return, let the IRS know I'm going to add my spouse's 12 million on top of my own 12 million. And now you have $24 million that you can give away to your kids or whoever you wanted, estate tax free. So you're really doubling your estate tax exemption. I really like portability. I generally advise portability to my clients. The only disadvantage, of course, is you have to do an estate tax return. And sometimes people don't want to pay their CPA to do that. But I think, the couple $1,000s that you might spend on the estate tax return is worth it if the total size of your estate is close to the exemption amount, close to 12 million. Or even if it's not close to 12 million, but let's say you're around 5 million, you want to think about that, because in 2026, that 12 million exemption is going to go away and it's going to go back down to 5 million, remember. And to be honest with you, we never know what Congress is going to do, right? So they completely change the rules on us and lower it even more. Let's say they lower it to 1 million. Now we're all going to be really focusing on estate taxes because it's going to impact way more people. So something to think about. When it comes to portability, before I move on from it, you have 9 months from the date of death of your spouse to do this. So don't wait too long. Of course, you know, I'm not saying you have to go see your attorney the very next day, but just to know that there's a time limit to what you can do with the IRS. Otherwise, they'll say it's too late. Similar, you know, you can get an extension, of course, a 6-month extension, but you still want to apply for that extension. Are there any questions so far? Or have I lost everybody?
So I have
Okay.
a couple of things you may want to think about. I'm old fashioned, so I'm probably out of date. But one was the old exemption was 675, not 600,000, not 600,000.
There you go.
And I did run into that, and my parents passed away in 1999, 98, and 2006. So, and one way around that is they wanted to do a charitable donation to a university. And I took the charity donation out of the IRA, which comes out tax-free, as opposed to having money taken out from my personal thing and then have to pay taxes on that and then donate it to the university.
Mm-hmm.
So
Absolutely.
taking things out of the IRA directly to a charitable thing is non-taxable out of the IRA.
Absolutely. So if you have charitable wishes, designating a charity as a beneficiary on your IRA or 401k is the way to go, instead of leaving other types of assets which are not subject to income taxes. So because the charities will take the IRA distribution income tax free, which is great. I think, Larry, you were referring to that, correct?
Correct. And then the other thing I did is we made gifting to the children and grandchildren, use that gifting money below the limit at the time, and bought the rest of my parents' assets. So when my father passed away in 2006, we already owned the property and saved millions in tax, gift tax, not gift tax, but inheritance tax.
Mm-hmm.
Just
Yeah.
another thought, but with that 12 million, really that doesn't pertain now because it's gone up so high.
Correct. Right. One strategy that people utilize, which is really a little bit outside of my area of practice, I don't really set up irrevocable life insurance trusts, but they're definitely a great way of planning for how to pay for estate taxes if you have a taxable estate, or if you want to reduce your estate taxes because you have, let's say, life insurance policies under your name and you want to get them out of your name because they increase the value of your estate. So irrevocable life insurance policies, they're obviously irrevocable trusts. So the idea behind this is the trust would be the owner of the policy, and it's an irrevocable trust. So you're kind of losing control over this asset. So you can't really make changes to the trust, but you select a trustee that you trust, you put beneficiaries of the trust. It can't be you, of course. The idea behind this trust is if you have a taxable estate, your beneficiaries, your loved ones don't have to sell the family home or your stocks and bonds to pay for that 40% estate tax. So just yesterday, somebody was asking me, how do we pay for this estate tax? Because I had someone in here who is a non-US resident. And for non-US residents, their estate tax exemption, if you can believe it, is only 60,000, so 60, quite low. And he owns a piece of property that's worth $1 million. And I told them anything over $60,000 is going to be subject to 40%. So in their case, they can, of course, set up an irrevocable life insurance trust to help pay for the estate taxes so that the house doesn't have to be sold because the family wants to hold on to it. So the life insurance, this type of a trust is a great way to pay for the estate taxes, or if you already own a life insurance policy, you can transfer that policy into this trust and your trustee would take over. And that way you have, you've reduced the size of your taxable estate. The nice thing about life insurance policies is generally they're exempt from income taxes. So we're generally not concerned about income taxes on the policy or on the distribution from the life insurance. So, okay.
I have a question.
Sure.
I'm of the mind that a good attorney knows the law, a great attorney knows the judge. And what's not being said or discussed here, and I'm just curious, wouldn't it make sense, or is there even anything legal behind someone getting a trust done in the county that they live in, or I should say an attorney that does business, has a practice in the county that they live in? Because wouldn't they know the laws more? Is there any problem when someone goes to another county for some strange reason, but resides in a different county?
No, because California rules affect all counties. So if you're in
Okay.
California, it doesn't matter which county you go to, which attorney you work with, as long as you're working with a competent attorney, of course, because the rules are going to be the same. If your estate goes through the court system, of course, the county that you were residing in would be the county that your family members would have to petition. They unfortunately, they don't get to choose. I wish we could. I would always pick LA probably better than Orange County, unfortunately, just because it's faster and the judges are a little bit nicer, in my opinion. I hope we don't have any judges here, Orange County judges, but so I don't think the county matters too much.
Okay.
Yeah.
Just curious how that all works. Thank you.
Absolutely. Absolutely. So future of estate taxes. So like I mentioned before, unless Congress changes the rules on us, which they might, because we have 4 years before 2026, but unless something changes, the exemption is going to be reduced back to 5 million. They'll adjust it for inflation. So it'll probably be about a little over $6 million. So if you have a estate that's around that, you're going to want to check your trust to make sure there's that AB provision. Maybe don't, I like the disclaimer trust option, which means that it doesn't require the surviving spouse to divide the assets, because you want your trust to be a little bit flexible. You don't want it to kind of lock you into doing something in case laws changed and then you never got a chance to update your trust. The disclaimer trust option would just give the option to the surviving spouse to do that AB division. That way the surviving spouse can pick and choose whether they want to do the AB split or they want to elect portability, which I like portability a lot. So I would probably pick that. So just be mindful of that if you have an estate that's around that amount. So definitely plan ahead. There are, probably more strategies than I got a chance to discuss today, but it depends on everybody's wishes, right? So if you have charitable wishes, if your primary goal is to leave your assets to charities, then you have, of course, a lot of options. There are charitable remainder trusts that you can set up, different kinds of charitable trusts actually you can set up. But if you don't have charitable, if you have, let's say, loved ones that you want to make sure you leave them money for, their education, their maintenance, their health, whatever it is, there's different planning strategies that'll apply to different people. There's not one size fits all kind of solution for everybody. Most important thing is, to periodically look at your estate plan, talk to your attorney. Sometimes your attorney will meet with you, free of charge, just to review it. Many attorneys do. I generally like to meet with my clients every year for 15 minutes to half an hour. I generally don't charge them anything because we just want to make sure everything is still exactly how you wanted it to be. We generally do a title search on your real estate to make sure the property hasn't been taken out of the trust, because if you've refinanced, like we talked about at the beginning, that might have happened. You always want to make sure to check your bank accounts are in your trust, your retirement accounts have beneficiaries. Sometimes a spouse dies and we forget to update our beneficiary designations. In California, the law requires us to put our spouses as the primary beneficiary on our retirement accounts, unless you get your spouse's consent. So what I see a lot is, and maybe Paula probably sees this a lot too, is people will forget to update their beneficiary designation, so it'll still have their deceased spouse as the beneficiary and no one else as a backup. So you want to check that. if you receive an inheritance or a gift, or if your estate grows over time, and you now have a taxable estate, you have a tax concern, you're going to need a new type of a plan. You're going to want to update your estate. And if you do receive substantial sum of money, you get, and you have an existing trust, you want to make sure you put that asset into your trust. So don't just leave it in your name. Make sure you put either beneficiaries or put it in your trust. So it's very important to plan for that. And then, of course, if you're married and your spouse passes, make sure to speak with your CPA or tax professional and your estate planning attorney within 9 months, because remember that 9-month rule. I had one client that came to me literally on the 9th month, and we filed for portability. So one more, month, and she would have lost that chance, and it would have been way more difficult to do planning. So with that, any other questions? Did we cover, the items that we wanted to cover? Is there anything that you guys want to hear more about that we didn't cover today?
No, I think that was a great job.
Yeah, it's a lot to take
A lot of
in.
information. You mentioned if someone passes, where I always mention to people on their investments, on either their life insurance or their IRAs, if you get divorced, you want to make sure you get rid of that person as primary beneficiary, because that can turn into a real hot mess.
Oh, yes. Thank you for mentioning that. Yes, divorce, I didn't talk about that, but that's a big one.
Yeah.
What I see is also people don't update their advanced healthcare directives when they divorce, and they still have their former spouses as the decision maker on their healthcare and their finances. And that's a big problem, because a lot of the times it's that former spouse doesn't want to do it. And so, or they'll do it, but they might not act in your best interest. So any big life change, you want your estate plan to reflect that. Same with a new child born. Or if you go through a divorce, your trust becomes invalid by law, actually, not the other documents, but your trust does. So don't think that you don't have to do anything. You have to create a new trust, probably.
Thank you so much. And Chala's office is right here in Huntington Beach. So get those. Like, I got to see when the last time mine was reviewed, but I'm going to call you. We're going to have lunch.
Absolutely.
And Natalie's not feeling well, so she's just going to give us a quick little update so she can go back to bed.
Oh, gosh.
But thank you,
Hi,
Natalie.
everybody.
Thanks so much for joining us, even though you don't feel good. She's not turning the camera on because she doesn't feel good, so we're going to let her be fun. So go ahead, Natalie.
Thanks, Cheryl. And I think my Wi-Fi is funky tonight too, so I apologize about that as well. It was great to hear about the trust stuff. Now I feel like I need to call you too. So,
anytime.
That's important for everybody. So thanks so much. Yeah, I'm so sorry. I'm not feeling well tonight, so I'm definitely not camera ready, but I'm here to, answer any questions that you have and just go over a couple of things that I thought were just something to note that you'd be interested in. You might very well know about them, but let me just share. So one is we are now in a level 2 water supply shortage per the state of California. So what does that mean? That means that our watering has been changed, and you've probably seen signs around town, which is just limiting the days per week that you can actually water the lawns with sprinklers. And so let's see, it's actually HB, I'm going to put the website in a minute so I don't mess up the information we're sending, but essentially it's Monday, Wednesday, and Friday between the hours of 5 p.m. and 9 a.m. is when it's limited to, effective June 10th. And that information has been shared on the city's website and social media, and again, around town on signs at multiple different neighborhood entries. So if you have questions about that, please do feel free to put them in the chat or let me know.
I think a lot of people in Huntington Beach, including myself and other people on here, we don't have to change our sprinklers, so we're waiting for the Saturday gardener to come out.
I hear you. I know we just redid ours, so I totally understand that. But yeah, I'm sure that they won't be enforcing it this week anyway, so you're good. Let's see what else. So in addition to that, and I think something of note, I don't think I mentioned it last time. I don't think we knew it officially yet, but the County of Orange conducted the point in time count a little while back, and we got the results back recently. The City of Huntington Beach's ongoing efforts to address homelessness fortunately have led to a 35% decrease in unsheltered homeless individuals, according to the point in time count conducted by the County of Orange. Really, there's so many different things we've been doing to try and kind of manage and work with the homeless in our community, really making sure that there's resources, including our navigation center, which was opened in December of 2020, including our Huntington Beach Homeless Task Force, which includes both uniformed officers as well as other task force outreach staff, in addition to our Be Well OC mobile crisis response team. So obviously everybody's experience can be different, depends on there are certain areas of town, that you might experience people who are experiencing homelessness more frequently, but do know things are improving, but we're still actively working on this. And in fact, at our most recent city council meeting, we approved an exclusive negotiating agreement to work with Jamboree Housing, Mercy House, who is our current shelter operator, as well as Be Well OC, which is the operator of our mobile crisis response van. Essentially, we have we'll call it a tent, but our sprung structure on Beach Boulevard, which is our navigation center or our shelter. And that's just a temporary structure. So what we're working with these different organizations and developers on is actually creating a permanent site that would look nice, number one, but would also really be a more welcoming space for different people, right? We found that the bulk of our homeless in Huntington Beach that have been reported are male seniors. That being said, I know we have a lot of senior women and women as well who are maybe in their cars who aren't up for going into a shelter or moving into that path because maybe they're afraid. So we're looking at things like separate spaces for women than men. We're looking, I think more importantly, at wraparound services like, sorry, the cold is getting to my brain, but wraparound services like specifically somewhere for people to be able to not detox per se, but just to kind of stabilize and multiple things with behavioral health, physical health, all of those types of things, and not just the shelter and navigating to housing itself. In addition, that would likely have permanent supportive housing and transitional housing on floors above the shelter. So we're looking to make sure that we can have really a really successful and sustainable system of care for our community as we move forward. So that's something that I'm very excited about. And I think that we're really doing some good work there. We, of course, do want people to continue to reach out. This is not something that's going to be corrected or fixed or done really any day. So do continue to reach out to me, to City Council. If you have an issue, you can reach out to our non-emergency line at the City of Huntington Beach, and then dispatch will determine who should be the right people to go out to assist you. Any questions on that? No? Okay. And then let's see. I don't know if you've all seen, we did there was a Sunset Beach update, and I'm actually going to put the link in the chat, which was really in a response or really summarizing a lot of the work that's been done since the shooting that occurred a while back. There has been a number of different things, which if you go onto this link, you'll see, but just to kind of go over them quickly, there's been increased Huntington Beach Police Department patrol in partnership with Be Well OC as well. So increasing those patrols throughout Sunset Beach, meeting to curb illegal behavior, while also doing outreach to those who are homeless or are in need of services. There was a homeless education class and information done a few weeks ago as well with United to End Homelessness that took place in the Sunset Beach Community Center there. There has been enhanced linear park lighting installed at the request of the community. And from what I've heard so far, that's been an improvement. And really the goal is to increase light output and visibility along the green belt there. There's also been improved park and beach signage, modified street sweeping schedule, added public trash pickup, And also they're making sure that the restrooms are locked at night to deter people from frequenting the Greenbelt past the posted curfew. So hopefully these items are helping. Of course, this is something that we want people to make sure that they're letting us know what's working, what's not, and we want to keep at it so that way it continues to improve. We do have our 4th of July parade is exciting. It's coming back on the 4th of July, but also if you go to hb4thofjuly.org, and that's the number 4, you can find out all sorts of information on the festivities. They actually start on Friday, July 1st at 3 p.m., going through Monday, July 4th at 10 p.m. So things like the carnival is back. You can go online. It's free admission, free live music, and there's going to be food and vendors and shopping there. But you can actually go on the website now and pre-order carnival ride tickets, and you'll get a better deal. So I recommend that. Also, let's see, so many things for 4th of July. I believe, the parade will be like it used to be, the large parade. We're very excited about that. And yeah, I think that's the bulk of things. So from my sick brain to yours, I'm happy to answer any questions.
It doesn't look like you're getting the VA Long Beach out there this year.
Getting the what?
What?
In the past, you've had the VA Long Beach with a group of veterans, disabled veterans out there. And
For the
I
4th
haven't
of
heard
July parade?
anything. Yeah, 4th of July parade. And I've heard nothing from the VA that they're going to send busloads of disabled veterans to be in the parade.
Well, there was the application to participate in the parade just closed, I think, a day or two ago. So I assume that they would normally apply to be in the parade. Nothing's really changed with regards to that, but feel free to have them reach out if they haven't.
No, I know they haven't. That's why I'm saying it's sad that they're not going to be in it.
Are they not choosing to be in it because they didn't want to participate, or they didn't know how to participate?
Oh, they know how to participate. I heard today that the policy is they don't want to do a function where there's more than 50 people. And there's more than 50 people watching the parade. So that's one reason they don't want to do it this year. That's the only thing I know.
So
they haven't applied.
Okay, so the veterans weren't comfortable doing it. Okay.
The VA, right?
Got it.
Long Beach
Got
VA.
it. That is unfortunate, but I understand that given the situation.
Yeah, I do too, but it's unfortunate because I've always enjoyed that.
Yeah.
No, I agree.
Well, thanks again, Natalie. Go get some.
Thank you. I hope you're feeling better.
Yeah.
Thank you so much. I appreciate it. I'm sorry. Next time I'll try to be back on camera. But please do. Meanwhile, not that you need to see me, but feel free to email me. I'll put my email in the chat. If you do have any questions or anything comes up that you want to discuss or anything, I'm happy to have a meeting or just have a conversation with anybody.
And thank you for the path around the lake.
Accomplished.
The path around the lake is first
You're
class.
welcome. Love it.
So we're gonna do some door prizes. Let me tell you the lineup of speakers for the next few months, because we've got some exciting stuff coming up. So it's always the third month. This Thursday came kind of quick because the first Thursday was on the second of the month, and so that kind of messed some people up. But Thursday, July 21st, we have a different spin on 1031 exchanges. So people that are just sick of landlords that are just sick of tenants, which we've seen a lot of during COVID, tenants that don't pay or say they have COVID or just take advantage of COVID. That's put a lot of landlords in the spot that they want to sell. They don't want to pay capital gains tax, but they don't want to deal with tenants anymore. We have a solution where you can, for example, maybe buy part of an office building and not pay those taxes. So that will be next month on the 21st. Then on Thursday, August 18th, Leanne, who's on tonight, is going to talk about identity theft, which has actually also gotten worse since COVID. So she's going to give people tips on how to protect your identity. And then Thursday, September 15th, do you really own your home? And you'd be surprised how many title records have been filed on. So we did this last year and we had a lot of people that, we had people that thought their home was in a trust and it wasn't. We even know an attorney who thought his home was in a trust and it wasn't. So we will be allowing everybody on there to get a free property profile, which will show them all the documents that have been recorded and how they've been recorded. So we got a good 3 months. We're always looking for speakers. So if there's something that you would like to be spoken about, please let me know and I'll find that person. I know so many. I think October, we're going to talk about aging in place. I've got a senior specialist that actually adapts homes so that seniors can stay there. So that's what's going on the next 3 months. If you know anybody looking to sell their home, we have so many buyers and so few homes to sell. And it's rising, which is making it even harder. So prices are kind of coming down a bit. Homes are staying on the market longer, but I'll tell you, if the home's beautiful and priced right, it will still sell very fast. It still is a seller's market. So we are going to do a door prize, and the first person to type in the chat box, look at the chat box. The question is, it's a yes or no. Do you need a will if you have a trust? Dave, the tech guy, immediately said, so gosh, that was quick. So Dave, I need you to text me your address. And would you like, do you want candy or coffee? I have a $25 See's candy and a $25 Starbucks card. What would you prefer?
I'll take the candy.
They'll take the candy. All right. So you have my cell number?
You know where I live.
You changed from you were DR a minute ago. So, okay, I know who you are. I know where you are.
I'm advertising now.
Okay, he changed his name and threw me off. But yes, I will drop that off at your house. And you want another bottle of wine?
Please.
Okay, I still have wine from my winery, and Dave likes it, so I give it to Dave. All right, so I will see everybody next month. Thank you, Chala, again. Paula, and we've got Adam on there. Stacy's still there. So if you know anybody looking to buy or sell real estate, please call us. We are working our tails off as usual. If you need an attorney, you got Chala there, and Paula.
I'll handhold people what they need right now.
Yeah. We need a lot. We need the shoulder to cry on.
Yes.
But if interest rates go up, that hopefully.
You know what? It's all going to settle. It's just a matter of having the patience to let it settle.
Little scary world out there.
It is.
Gas prices will go down. Interest rates will go up on our savings accounts and down on mortgages. The perfect world, right?
Yes.
Wishful thinking. Good night, everybody.
Thank you again, Chala.
Thank you.
Natalie, feel better if she's still on. Take care, everybody.
Bye.
Bye.
Everyone, thank
Carol.
you.
Thank you.